Motion?
I'll set.
Thank you. Okay, the meeting minutes are accepted as written. We'll move on to the committee reports, the Domestic Violence Coordinating Council. Amy, do you have anything for us?
Hello, good morning, folks. We met to review new legislation in October, and we're getting ready to meet again in February for the next DVCC. So group subcommittees are continuing their work, so not a whole lot new going on. We hope to look towards having a in-person conference, but that's a lot of work, so let's see how it goes. That's it, thanks.
Great, and Tanya here.
Hello, good morning. My name is Candice Johnson. I'll be stepping in on behalf of Ms. Smith. She is under the weather today. Just a couple updates from the forensic work group meeting. We had a presentation by All Over Healthcare. It's a pretty good organization. I actually work with them directly. The presentation was by Mr. Okoji. Don't know if I'm saying that right. We had some updates from myself for the mental health and wellness program. We had Ms. Kiana Harris, the reentry coordinator, coordinated another successful resource fair at the jail on November 2nd, and they will be giving away 25 poem books that have been donated. I'll let Mr. Sirleaf say any updates that he needs to say, and that is pretty much it. And I'll leave it with that.
Everything is working fine.
Does anyone have any questions or comments for Amy or the forensic worker?
Do you know how many people we have right now on mental health holds waiting to go to the Department of Health?
I don't have that particular number right now, but I can leave it to you.
That's fine. Thank you.
Okay, so we'll move on to our presentations. We're still on the mental health topic this week, and we'll be on the mental health topic for February as well. So today we'll start with corrections.
All right. Yeah. You were happy.
I do.
Yes, ma'am. All right. Good morning. Again, my name is Candice Johnson. I'm the mental health therapist at the Mental Health and Wellness Unit program at Baltimore County Detention Center. Ms. Tanya Smith and myself went to the AJA Summit for Mental Health Professionals. For jail professionals in October. And so we just have an overview. It was a lot of information. So we have the PowerPoint is a little long, so I'm going to be as fast as I can. We had a couple of handouts for the information that was kind of condensed from the whole conference. So, yeah.
Sorry about that. Having some.
Technology.
Yeah.
I kind of augment it.
Yeah, that's what we're trying to do. Oh, the mouse isn't working.
And we're on one screen, so I think that might have something to do with it. It might be stuck over here.
Something else. Anything to my desk most of the time.
Yeah.
Sorry. Okay, so while they're pulling the PowerPoint up, so some of the overall goals of the conference were to discuss the challenges that some come into contact with in the corrections field between staff retention and caring for their own mental health. Okay. that was the main goal of the conference. How do we improve staff morale and address their own mental health concerns? All right, so on behalf of Ms. Tanya Smith, this is her part, she went over some major issues. First, correctional employees endured a significant amount of stress and feel undervalued. So that was one of the major concepts that was discussed. So what can we do about this? Communicate, increase communication, ask directly what their personal needs are, encourage help, and let them know that this is not a short-term fix, but a long-term goal. So some things happen and you address that need and that's it. But we know, I know as a mental health professional, depression just does not go away because you solved a problem. So that is one of the major concepts that they were discussing throughout the whole. How do you deal with the person, not just the problem? So, all right, so there's no one size fits all for staff mental health concerns. All right, how to build a safety net for staff wellness. So we all know directors are generally way too busy to address this concern. So one of the major recommendations was to establish a full-time wellness and retention coordinator. This person should be a champion for the cause, not just a random person or voluntold person. This person should be a seasoned employee that doesn't have to be a correctional officer, but does have to have some lived experience so that that person can relate to the staff needs. And this person should ideally be a person with a good rapport, a people person who is sensitive to mental health needs. Okay, so one of the major, I guess you could say, promotions of the conference was to establish a peer support team. A peer, meaning another corrections staff member who has a direct rapport that can spread the word about mental health and wellness among staff. Person, like I said earlier, a champion for the cause. So, open recruitment is key to allow the people who are motivated to come and present their desire to be this person, this peer support team player. Well, all right, technical things. Oh, she's doing something there. Okay, no problem. All right, responsibilities of a peer support team. They will be the conduit for employees to openly express themselves about personal and professional issues in a non-judgmental manner. They may be the person that sits with them at a hospital after being assaulted by an incarcerated individual. And they may be the person that sits with them after they receive a call at work that a family member passed away. So a peer person who has a sensitivity to mental health needs without this fear that because I have a mental health concern that I may be sat down or reprimanded or seen as weak or seen as not competent because I'm going through a mental health crisis or pre-crisis or minor issue, right? Because we all know, we all have mental health concerns and we're all human. So we have to address that as such, especially in the corrections environment, because we know daily they're under constant stress with not only the schedule, with the individuals and the things that the people say, as well as their own personal mental health or family issues that they bring to the job. So that was the main point that they were trying to make, that these people they're people, they're not robots. Okay. So this person can also inform colleagues about the House of Ruth for domestic violence situations. They can also help staff decompress after experiencing their first serious incident. Okay, so this person can also be a social coordinator. So this person can engage the staff in morale boosting, coordinating potlucks, things like that, ensuring that staff feel connected and not just a uniform. Okay, so that was Ms. Smith's target focus for the breakout sessions that she attended. So how do we get started in that particular point with the peer support? We could take a survey to engage the interest of the staff. Visit another organization who's already doing this, and why reinvent the wheel? reach out to other agencies regarding training, which I will talk about later, and develop a policy that outlines this particular program. And just get started. Okay? Any questions thus far on what was talked about? I would say that was the main overall focus, and then we have some more individual focus on mental health concerns. Any questions? All right. So I attended different sessions. The first session I attended.
We're waiting for IT, sorry.
They're on their way.
Yes. So the first session I attended was what's going on, how our body and mind respond to what's happening on the outside. All right, so raise your hand if you are familiar with mental health, whether personally or professionally or third party. Okay, great, wonderful. I'm sure you all use it in your profession. So what a lot of people don't know is how trauma works and how it produces different behaviors in the individuals. So one note from this session was that our brains create habits in the face of trauma, right? So we know if you're here from corrections or police or fire, individuals may experience trauma on the job, right? So trauma is a reaction, not a memory, right? We can all experience the same trauma and have different reactions or responses, okay? So the goal of this session was to understand the individual and how they responded, right? So an individual may have their own level of resilience, which would cause them to be less responsive or less reactive to particular traumas, whereas most may not. So we have to understand how each individual reacts so that we can respond accordingly. Not everyone has the same level of resilience. And we do have to be aware that some people may hold in those trauma-like or PTSD-like reactions internally, and it may come as a response later, okay? PTSD is not always immediate after a trauma. Is anybody familiar with that idea? Okay, PTSD can come years later, okay? So just to understand how if someone were to be assaulted on the job, right? You guys all are familiar. Okay, if someone's assaulted on the job, they may just cope right then and there. But weeks or months later, now they're experiencing or re-experiencing the trauma, okay? So we have to be able to have an open dialogue so that the individual can address any of those reactions that they have, okay? Hypervigilance, poor sleep, flashbacks, etc. Okay? So during trauma, memory recording is thrown offline to make way for survival instincts. So you may see an individual, let's say it's an officer who responds to a trauma on the job, and they respond in a certain fashion. That doesn't mean that that person was fully aware in that moment. They may have been in fight or flight mode, right? So sometimes we don't understand why they did what they did in that moment, right? So afterward, it's very good, very important. I know you all have to debriefing process, but to understand how the memory works. So if they're writing reports, it may not be a chronological situation. A lot of memory of trauma is recorded as a sensory experience. So what I smelled, what I heard, what I felt, right? So sometimes it may just seem like discrepancies, but in reality, it was trauma, right? Jumbling things up. Does everybody understand how that's going? Okay, wonderful. All right. Nope, it's not coming up yet. I had a nice visual. I really hope it's all right. PowerPoint was nice and pretty and everything. All right. So that was more of the mental health aspect, just to educate people who are not familiar with mental health, how it works, how trauma works. All right, the next session was protecting the mind behind the badge, the role of psychological safety in corrections officers' retention and wellness. Okay, so let me ask you some questions. Let me quiz you guys. For what branch of, let's say, public safety is suicidal ideation greater? A, police, B, fire, C, combat veterans, or D, correctional staff? What do you guys think?
So you have to see.
C? So what was that?
I say C.
Okay. And what would you say?
See, combat.
Okay. Anyone else? All right. It's actually rated for correctional staff. Correctional officers also face divorce, marital and family issues,
There,
at a higher rate.
go to slideshow.
That's
Slide
Yeah.
14.
All right, so correctional staff face higher rates in these situations, suicidal ideation and marriage and family conflict, as a result of work stress and missing time away from family. So if you think about it, right, there's different levels of training to enter each of these different professions. And we may not always have individuals who come with a set of training, or let's say weed out, if you weed out a certain type of person to enter a certain level of stress. The people who make it may have a higher resilience. However, we know corrections is open to the broad population, right? So we may have a lot of individuals from varying levels of resilience, varying levels of life crises, situations, and mental health. Okay, let's see. Yes. All right, the next one. All right. So the next session is creating an oasis of wellness for your staff. So that sounds great, doesn't it? Oasis of wellness. Can I ask the group, how would you create an oasis of wellness for your staff? Ideas, let's see. Sam?
Yeah, we have an oasis.
We have
around.
You need to go to BSS.
Sound chairs, song light, music, waterfall, machine. Jacuzzi.
So this was a basic working group session. So there was a plethora of ideas that came out of this. I'm just going to touch on a couple bullet points. If you would like the more detailed version, you can send out the email to the group. That would be great. If you didn't already get it. All right. So they have some suggestions. Reading this book, I Am Not Okay by One Voice, discussing mental health crises facing correctional officers, and other frontline staff. Let's see, there was this kind of idea, like a nice wellness room, healthier options, having more on-the-job social interactions like religious and spiritual, this was a major point, identifying and connecting staff with a culturally competent therapist that understands corrections needs. So corrections officers, just like police and fire, they speak another language, right? They have a whole nother set of experiences. So for a therapist to really relate, as a therapist, I have a lot of my clients come to me and say, well, I just couldn't relate to that person. They didn't understand. They didn't know where I was coming from, right? And so they don't stay in treatment, right? So you want your staff to stay in treatment. That would be better for them, right? So to be able to, on behalf of the peer support team, to identify in the community or outside of the community, a therapist or a set of therapists that are specifically designed for your agency to maybe set aside some time in the week so that those individuals have a slot. So if something comes up, they can go talk to that therapist. And it's an open door. Okay. And privacy and confidentiality are very important because we know that corrections officers work, they may live in the community where there's some incarcerated individuals that may exit, right? And they don't want to interact with them, and they also don't, as a client in a therapy clinic, right? And they also don't necessarily want their business in the community, right? So finding a nice, maybe distance therapist, or it could also be online too, right? So there's a lot of resources that you can think of, but just do be considerate of the dynamic that the individual. A lot of individuals are very guarded with their mental health, so they may not be so open to seeking treatment. So if you make it a little bit more accessible to them, they will be more likely to go. Okay, that's.
I'm sorry, in the interest of time, if you have a couple more thoughts.
Sure.
And then I'd like to ask corrections team to present at the next meeting on mental health concerns and interaction with kids. I think that's going to be a really helpful topic for this group. So I just want to make sure we have enough time to get through our presentations. Thanks.
Well, okay, so the last one, I'll just touch on it. The last set, I do have only, I think, 12 copies, but the last set was a comprehensive list of different ideas, like this young lady mentioned right here. So many different things that you can incorporate. And of course, there's funding available for ideas and trainings to get this information, but to increase staff morale, increase their access to mental health, increase their staff sensitivity to mental health needs, and encourage them to be open with their mental health concerns would be my takeaways from that. And let me just make sure. You can skip all the way down to slide. I will not read the comprehensive list of ideas. Questions to ask. Ask your staff, when do you feel like your best self? What are you doing when you feel like your best self? If nothing changes on your job, what are you going to do? Meaning coping skills. What are your small or large triggers? Asking your organization, what does a peer support team look like? Is our organization well, meaning wellness? Not just operating, but well, mentally well. How do we change the culture of wellness, mental health? You know, some things are taboo and staff do not like to talk about certain things. But how can we start changing that culture? The main points, changing your culture, people first approach, and follow through with any initiatives that you have started regarding mental health. So that is about it. And does anyone have any questions? All right.
Thank
Thank you.
You're welcome.
So we want to mental health for Judge Wilson, Judge Davis?
Judge Davis will be presenting on behalf of the
Great.
board.
Okay. Good morning, everyone.
Morning.
All right. And our presentations are going to look the same because I happen to use the same template. So, totally different content, but the same layout. So, good morning. I am Kimberly Davis, District Court, Baltimore County, and thank you for having me here today to present content about our mental health court program. And I know that our programming gets somewhat confused. I don't know if is it easier for me? You can look at the PowerPoint. You don't need to look at me. I just kind of walk and don't keep still because I sit all day. So when I get this chance to walk, I like to walk. So is that distracting for anyone, or would you like for me to stand still? I will bend to the will of the group. Okay. All right. So here's our PowerPoint. The District Court of Maryland for Baltimore County competency docket and our mental health court programming. These are all under the umbrella of mental health, but they are two separate dockets. So I will explain. And the agenda, we're just going to do an introduction brief. Explain competency, the mental health court program, do a summary, and I'll take any questions or comments. So if you're interested, the statutes for competency, there are other rules, other things that we're guided by as far as case law, but the criminal procedure article sections 3-104 through 3-107 are where you'll find preliminarily all of the law or competency. Earlier in that, from 3-101 to 3-103, you'll find other relevant statutes. But when you're looking at what the court, how the court operates, typically on competency as far as what we're doing and handling cases for competency when they first come through the court, this is what governs us. So starting off with competency. And I'm trying to move quickly, so stop me if I'm going, or tell me to slow down if I'm going too fast. But the definition of incompetent to stand trial, when you have a person, when the court has a person who comes in front of it, or even if defense counsel in their interaction with a person believes that the person, the defendant, is not able to understand the nature or object of the proceedings, or if the person is unable to assist in his or her defense. It could be both, depending on the position of the person. So you could have a person who totally doesn't understand what's going on. It could be a trespass case where they believe they own the property. So they don't understand the nature or object of the proceedings because in their mind, it's theirs. Or it could be an arson case where the person is trying to get rid of something in the property that no one else sees but them. So that's not, they don't perceive it as an arson. They perceive it as eradicating an issue. So also, if the person is unable to or unwilling to communicate with defense counsel, then you have the inability to assist in the person's defense. So a competency evaluation will be ordered if counsel in their interaction with the person says they don't understand based on my interaction with the person, and they can't assist me because sometimes parties don't want to talk with the attorney, or when they do talk with the attorney, they can't effectively communicate. So counsel will ask the court to issue a competency evaluation, and the court will order one. The court can also order a competency if a person is not represented by counsel but comes before the court and can't engage, or we see all kinds of situations, as you can probably imagine. But if a person doesn't understand the nature or object, or even if the court's trying to communicate and the person can't communicate with the court can order the evaluation on its own. So if a competency evaluation is ordered, everything must stop. So if it's at bail review, the bail review cannot continue. If it's on the trial date, the trial will not proceed. The person will not take a plea. If the person is possibly in a position where they could be incompetent, you don't risk that. You stop and have the person evaluated. And so the Department of Health, the Maryland Department of Health, will prepare a competency evaluation. Oftentimes, here in Baltimore County, we also get evaluations from Dr. Siebert's office. So you all know Dr. Siebert, but they go to different places. So we might get them from different different providers. However, we review the evaluation. They usually come to me. Before me, it was Judge Chervasi and Judge Lyman. And I think it may have been Judge Williams before them, but now it is, they come to me at this point and I review them. And if the person is opined to be incompetent, then the matter gets set on the competency docket. If you want to move to the next slide, we'll go to. So if the person is opined, and I'm sorry, it's a lot of content, but I wanted to try to be thorough, but quick. If the person's opined incompetent to stand trial and dangerous, so there's a difference. If the doctor says, okay, they don't understand the nature and they can't assist counsel, then that is the first prong. But if the person is opined to be dangerous, then the person will be committed to the Maryland Department of Health. So the matter is set for a hearing. Either way, if there's an incompetency finding, they've got to come to the competency docket. So I call it the mental health docket. So it's been the mental health docket for a while. However, / competency. So these dockets are held on the 1st, 3rd, and 5th Tuesday of the month. And they are via remote proceedings, meaning the defendants or individuals who have been found to be incompetent and dangerous appear via Zoom. And I'll step back and talk about that in a moment. But if they're incompetent and dangerous, then the matter is set for a hearing. The parties are committed to the Maryland Department of Health and ultimately admitted to a Maryland Department of Health facility for treatment. And the matters are set for periodic review hearings to assess whether the person remains incompetent. So when they are sent to the hospitals, Spring Grove, Springfield, they go all over the state depending on bed availability. They're there for mental health treatment, but also competency restoration services. And so if a person is incompetent to stand trial, but not dangerous if they remain in the community or if released into the community, then they'll be released with community services and set for review hearings. Typically, those review hearings are set every year, depending on the viability of the case. So, for example, if it is a trespassing, or a case that has a 60, 90-day maximum sentence, then those are going to come back for review very quickly because they can't be committed or the cases won't be viable after that period of sentence. So the state monitors that and they ask for a particular hearing date based on the viability of the case. And state and defense agreed on the date. It's set for a review hearing and it comes back on that date for review. When it comes back for review, prior to that date, the Maryland Department of Health will prepare another report to give information as to whether the person has been restored to competency, or if not, then it's reviewed to see whether the case is still viable. Okay, so I didn't want to not address the issue, but I'm not going to stay on this issue for very long. We all know that there's a delay in placement for individuals who have been opined incompetent and found to be incompetent and dangerous. So let's stop. If a person is found to be incompetent and dangerous and the court signs the order of commitment to the Maryland Department of Health, person should be moved to the hospital within 10 business days per the statute. There's a bed shortage, as most of us know, and the Maryland Department of Health has been unable to move parties. Now, what has the court done? Now, I wanted to just explain a little bit about some other things that I do aside from presiding over the document. So I am the chair of the Specialty Courts and Dockets Committee for the judiciary, the Judicial Council. And one of the things that the Behavioral Health Subcommittee did was ask the secretary and one of the deputies to come and meet with the Behavioral Health Subcommittee to figure out what's happening, what can be done to have people moved quickly. They did come, they did present, they did explain that the issue is on the front end with bed space, moving people from the detention centers to the hospitals, but also on the back end where people have been restored or ready to be moved, but then there's a lack of community placements. So there's a bottleneck at the top, bottleneck at the bottom, and so it's, well, what are you doing? And so there's an open discussion, and so I won't take up much time, but I will say to you that it is not an issue that the court is ignoring. It is not an issue that the court says, okay, well, just, it'll fix itself, but the court is controlled by ethics and its rules and what we can do and cannot do. But I know that there's an open discussion and it is an issue that the court does not take lightly and would hope that this situation is corrected very soon, because we understand the need to have parties treated and to have their needs met for competency restoration as well as mental health treatment. So it has been addressed with NDH and it's an ongoing conversation. Okay. So what happens next? Well, if the person is at the hospital and competency is restored, it can be restored prior to the hearing date that's set. And if it is, and I get a report, I set it in as soon as possible to have the person proceed to a bail review hearing or for the matter to proceed to trial. So, for example, if there's a person who's been found to be incompetent and they've come onto the competency docket and we've said, okay, well, their review date or their status hearing date is not going to be until April. But if I get a report in January that says, hey, they're compliant, they're taking their medicines, they're better, they're competent, and they've been restored, then I'll set it in on the next date, which if I got that report today, the next hearing date would be this coming Tuesday, December 19th. So those matters don't wait. The importance of them not waiting is the person should proceed to trial, number one, or to bail, if you can have the matters proceed, but also it's important to move the person because someone else needs that bed at MDH. So the court is doing what we can do to make sure that we move people through the proceedings so that they get to hearings and trials expeditiously, but also for bed space. So if a person is restored if they were evaluated at the bail review hearing and the bail review had to stop, then they would place back on the bail review docket. I will tell you that if parties have been incompetent for a period of time and been in the hospital, they do come with a preliminary aftercare letter. What that is a letter that indicates all of the services that they may need and that have been planned for them in the community, so that if the judge can release them on their own recognizance with their therapy provider and with maybe substance use treatment, that comes from MDH, from the hospital. And so then the judge can say, okay, this person can be released on their own recognizance, go into the community, and they'll be released with the special condition that they comply with the content and the terms of the preliminary aftercare letter. That way they can remain competent, proceed to their trial proceedings, they'll get their trial date. So if they've already been to bail review and somewhere after bail review competency came into question, then they don't have to go back before bail review unless, well, they don't go back for bail review, but the court can review what their status is going to be in the community. But it's not necessarily the bail review docket. It's, okay, the person may be released or may have to stay in the jail. So, but they would be set for their trial if they've already been to bail review and their proceedings are right for a trial. If competency is not able to be restored, the defendant will appear for a hearing, and if the person remains incompetent and dangerous and not restorable within the time period for those charges, so if it's a charge that has a very small window of time, 60, 90 days, that's going to come back a whole lot sooner. If it's an assault case or something a little bit longer, that may come back within maybe, I think it's 3 years. So that person may be in the hospital for quite a while, and if they can't be restored, then the person is subject to involuntary civil commitment. So they'll be committed to the Maryland Department of Health. The case then will be null-prossed or dismissed. So the criminal case won't remain, but the person will be committed to Maryland Department of Health for them to be treated. If the person remains incompetent, not restorable, and not dangerous, the person will remain in the community with their continuing services, and the state may choose to just dismiss or null-pross the charges because the person is no longer, the case is no longer viable, and the person will not be restored within the time limits for those charges. Any questions so far? Yeah.
I'm with juvenile services. Is that 10-day statutory? Is that similar
For
to our young
juveniles?
people? Yes.
Juveniles are different.
Okay.
Because
Because I've never heard the 10-day, and I was just wondering, because our youth languish in detention pending, they've been found after an evaluation and should be transferred, and they're constantly being sent to a hospital because they're, in a detention center, and they're like eating staples or, doing things that harm themselves. So I was just wondering, I'd never heard of the 10 days, so I was wondering.
10-day movement to the hospital.
Yes.
Juvenile's different. I could look it up, but because I'm not handling the juvenile matters, I
I was just
couldn't
wondering.
say.
I don't know. Yeah.
It's always circuit.
That is circuit.
Yeah,
But-
yeah, the circuit.
But
yeah.
who handles, does anyone know who handles the juvenile competency matters? They may just be encompassed in the juvenile docket.
Okay.
So whoever the judge is that handles juvenile,
Magistrates usually.
magistrates handle it.
I just met Judge Bailey, so.
Okay.
I was just gonna say, I think
Yeah.
there's Sherry Bailey.
Just met her, yes.
is Juvenile
Okay.
issues, so that might be
I'll ask her, yeah. Thanks.
somewhere.
There was enough, yes.
What happened to those that are not from this country, that are charged with simple trespassing, and have refused to cooperate with the court, and the court have deemed them incompetent? After the sister did, what happened to them?
After the what date? The
After the sister did that we were talking about earlier. If the person went to court and refused to speak, they deemed that person incompetent. We have a case now at a jail where a lady who is from Germany in house have refused. In fact, I spoke to her yesterday. She said she speaks very well. she said she would not cooperate with anybody because she was traveling to Canada and she was,
Speaking of.
okay. So,
And if a person if there's a language barrier, then I would say that we have an interpreter that comes in that interprets. And so if there's a language barrier, you're talking about someone just from another country,
yeah, and this one has no language barrier. She speaks very well.
we still use an interpreter with her,
Okay.
I would say.
So,
Is
Yes.
your issue, is your concern the fact that she's not from the United States?
look, just if you relieve, if you relieve her, where, how is she gonna go? Where would she go?
I don't think that she's, okay, I understand what you're saying. I can't get too far into that.
Okay,
If she has ties to the community, once she's found to be competent and restored, if she has ties to the community, she would be released into the community. If she has to wait once she's restored and she may not have ties, or she may be dangerous, or if there's something going on, they're treated like any other bail review. So it's not a matter of where she's from, it's whether she has ties, whether she's at risk of flight, whether she's dangerous. So, I mean, I'm not sure if I answered your question.
And Your Honor, if the question of whether someone is just refusing to cooperate or actually has mental health issues is part of what the court navigates through the evaluation process.
Right.
And then the service providers just receive whatever the outcome of that process is.
Right. So I reviewed the competency evaluation, and it's not that a person just doesn't want to cooperate. The doctors will tell us that. They understand. They're perfectly capable of understanding. They just don't want to. That's the same as some people who come in and it's not competency is not an issue. They just might disagree with the proceedings themselves and, life as we know it. I mean, I think that's not necessarily a competency. That's they don't agree. And that's what trial is for.
and, that's what we face now, but she doesn't have any tie within the states.
Well, that will be reviewed once she's found to be competent and whether she proceeds to trial or not. So that has to be addressed as she proceeds through. But
Could you handle it the same way if a person were, say, homeless? And they were in that same situation? Don't have a house to go to, no family in an area, just been sort of roaming the streets and living where I can.
right.
And it would probably, you're incompetent to stand trial, competency back, but we think about the same thing as a person who might be from a different part of the world. Doesn't have family or ties here.
It's not about the person's circumstances, it's about their ability to understand the proceedings. And I think we're looking at more so circumstances once they're restored. And that maybe, it might be you're thinking that maybe she's incompetent because she's not from this country, or maybe there's a language barrier, but I don't think that's it.
No,
I think that there was something else with the,
If
that-
if you relieve her, my concern was where will you place her if she don't have any tie in the community?
well, but you can't always hold a person if they're not dangerous. It's more if they're dangerous or a risk of public safety, or if they're a risk of flight. Sometimes the court has to say, listen, we're gonna put you on pretrial supervision and you have to check in, and here's your court date, and you have to make sure you're here. But that's a different discussion. That's a different, so hopefully I answered your question. But that's more so when the person's restored.
Judge, did the
Yes.
Secretary of Health give you a timeline when they're going to fix this issue?
No,
Like nothing. Because it is, when do you retire? It is the one thing that I am so focused on is we just don't care as a state. And that's bothering me. And I'm not saying you, Judge, I'm saying us collectively as a whole. And it really, it bothers me that we have people languishing in the detention center. I talked to Ms. Johnson, I talked to Ms. Smith, I talked to Mr. Sirleaf every week. That list does not get shorter of people sitting in competency. It grows. We're 20-some people. And I know I'm singing to the choir.
no,
I
you
get
are,
that.
you are, and the answer was no. The answer was no.
So what
Is
This is
there
where
a
we
timeline?
need to have pressure put on the Department of Health by the courts, by the public defender's office, by the state's attorneys, by the county executives, by everybody to basically come up with something that's gonna fix the issue, because the issue has been around now for 2+ years. It's not getting better.
It has, but the issue has been around. And I would just say that that's why I raised the issue. I think if I don't raise the issue, it's like, okay, she glossed over it. I'm not gonna gloss over anything.
I get that, yeah.
But to answer your question, no, there was not a timeline. There was discussion about what actions are being taken with them trying to address the issues. And they're taking action. Is it quick enough for any of us? No, I don't think so. But I think to answer your question, no, but yes, there's action being taken. But I think more so, that's an issue where everybody has to come to the table again with the Maryland Department of Health and ask them questions. But that's not something I can only, and Judge Wilson can only, and my colleagues can only do what we're supposed to do and maintain our diligence in making sure that the matters come in as soon as possible and handle it the way. But to answer your question, no, a timeline was not given.
They just, in our last, ward meeting, they just, told us that, 50 beds will be available in 2025.
Well, I think that there's beds, there's an accommodations, trying to make accommodations for beds, but also when you have beds, then they're saying, well, we also have to have people to staff those units, because if you don't have people to staff the units, then it's an unsafe situation. You're putting the staff in jeopardy if you don't have enough people to staff those beds. And then you're putting the other, the patients, the people who are admitted, in danger because you don't have people to staff it. So it's an ongoing issue or set of issues that they are saying that they're trying to address, and it's an ongoing dialogue.
But the updates they give are the same thing.
Over and
Because our
every
secretary,
update, the exact same
like,
thing.
Yeah.
I know our secretary has asked for an update,
Mhm.
and it shouldn't be the exact same thing. And it's not just adult beds. We need beds for juveniles
Right.
that are, I mean, desperately need beds for juveniles. They do not need to be in a delinquency placement. They should be in a mental health facility. And the updates that we are getting are the exact same thing. It's going around and around. And it's like people forget that juveniles need, they have needs for mental health and stuff.
Can I just chime in with just an update? I'm a part of the Administrative Judges Committee, which meets with Chief Judge Morrissey periodically throughout the year, and all the other administrative judges of the district court, not the circuit. Circuit Court has the Conference of Circuit Court Judges, and they have their own separate meetings. But I can tell you just recently, last Friday, we had the Administrative Judges Committee meeting, and the very first and lengthy topic was mental health. And I know that Chief Judge Morrissey and others have regular calls with the secretary to discuss this issue. He sends out regular information that he gets from the secretary. And I am under the impression that there is a bigger initiative that is in the works. It may be based on some models that exist in some other states. But the judiciary, in collaboration with the Department of Health, is looking at this issue and working on it. I do not know all the details of what that model will look like, but I do know that this is a top level, high level discussion that is happening, and even with Justice Fader, who has participated in a number of these calls. So pressure is there. It is coming from the upper levels of the judiciary. I can tell you that. And pressure is there. The hope is that the secretary and the Department of Health will make the move that needs to be made. And I think some of it is a commitment of resources, money. So I just wanted to at least share that with everybody.
Thank you. And the funding that they were discussing, even in the meeting that we had back in September, it doesn't only go for adults. They were saying there's an allocation for juveniles as well, and there's an initiative for juveniles. So, and I'll also share with you, as Judge Wilson indicated, our Chief Justice was in that meeting along with our Chief Judge for the district court. So this is not, that's why, I say it's not something that's going unaddressed, unnoticed. It's just that it has to happen. So, any other questions or comments? All right, we'll move on. All right, so I'm gonna now fast forward to our mental health program. So the program is different than the competence docket. The mental health court program is a docket that is a specialized problem-solving court. It provides specialized supervision for court-involved individuals with diagnosed or undiagnosed mental health disorders. And so it's designed to reduce recidivism and promote stabilization and maintenance of mental health and productive engagement in the community. So these are parties who are competent, who have mental health disorders that require specialized supervision. So this docket meets on the second and fourth Tuesdays. So we actually have one that's going to be today. Next slide, please. So as I indicated, these are,
Oh, I'm sorry.
yeah, thank you, for competent individuals. And this is a voluntary program, so people can elect to come into this program. And so the parties are screened by our problem-solving coordinator, and then if deemed eligible by the Office of the State's Attorney. So our problem-solving coordinator is Ethan Stansberry, and our state's attorneys, our assistant state's attorneys who are assigned to this program are Michelle Fuller and Jessica Boris. So either Ms. Boris or Ms. Fuller, typically Ms. Fuller will do the evaluation or the assessment for eligibility on behalf of the state's attorney's office. And once the person's deemed eligible by both the problem-solving coordinator and the state, the person will, with counsel, determine with the state what track they're going to enter in on. And so if you could go down to slide 16 really quickly. So the parties will work with the state to determine whether the person is going to come in on a pretrial basis, a post-plea basis, or a post-sentence basis. What that means, if the person all of the persons who are screened must be high risk, high need. So if a person is not high risk, high need, they are not going to be eligible for the program. Some people are referred, but don't come into the program because they don't have the needs or they're not high risk. So they don't need this supervision. Over the course of time, when problem solving courts first started, let's go back, everyone was just thrown in. And you had people who were high risk, high need and people who weren't high risk, high need. You may do more damage to a person who is not high risk, high need by giving all of the supervision. So now problem-solving courts are typically just applicable to parties who are high risk, high need. So depending on the posture of the case or what has happened, the state and defense will talk. They will, as in any other matter, they will determine whether the person is going to come in on a pretrial basis, do their treatment, and accept the specialized supervision. And once they are finished all 4 phases of the program, receive a no pass or step if they successfully complete. There are other parties who come in post-plea, so they will plead guilty or not guilty, agree statement of facts. If they're found guilty, they won't be sentenced. They will go into the program, complete the program, and if they complete successfully or are terminated for some other reason, then they will receive their sentence. But that's to focus on successful completion. So with successful completion, they will receive their sentence. Then also we have post-sentence, and those parties will be found guilty, placed on probation, and their successful completion of the program is a condition of their probation. All right, so then can we go back up to, I believe it's 13. Right. So eligibility requirements. Baltimore County resident, over 18, evidence of mental health issues, diagnosed or undiagnosed. The pending case may evidence the existence of a mental health disorder, and the pending charges, history of offense or other convictions may be influenced by, related to the offender's mental health issues or disorder. Could also be a violation of probation related to influenced by mental health disorder. And eligibility criteria, the state and program coordinator and defense can talk And they can discuss these on a case-by-case basis if the person may not be a county resident. They could be a city resident, but have transportation, be able to come into the program. So those types of issues, but they all are adult offenders. Okay, next. So who's ineligible? History of violent felony offenses, because this is typically for the district court, nonviolent offenders. And then violent offenses are, your murder, rape, sex offenses, burglaries, even though burglary is negotiable. Arson, kidnapping, any assaults, any attempts to commit, or any of those other offenses, and then use of a firearm and commission of a crime. Possession with intent to distribute is determined on a case-by-case basis. And any of the ineligibility criteria can be discussed by the team. And if a person would otherwise be eligible but for, they can determine that the person can come to the program. So what are the areas of focus? When we're talking about our specialty court programming, the competent individuals, mental health diagnoses are the primary diagnoses. So you may have a person who has substance use disorder as well. But when we're looking at our problem solving court programming, because we do also have a recovery court, for mental health court, if the primary diagnosis is a mental health disorder, then that person will be screened and enter the mental health court. And the resources are, we're looking at a holistic approach, housing, employment. The providers, one of our providers will even assist with insurance and giving treatment pending insurance approval. So we have some really good resource providers. A couple of them we've gotten from the jails meeting that they do with the reentry. And so we appreciate that because you have a lot of really, really great providers that come on and they're great resources. So treatment for co-occurring disorders, as I indicated, sometimes we have parties that have both substance use and mental health disorders. So it's what's the primary disorder. So with substance use disorders for mental health court, it's secondary. But we actually have an individual right now who was screened and the treatment recommendations, he's coming into mental health court, but his treatment recommendations actually indicate that he has substance use disorder, not a mental health disorder. So we're going to decide today and probably transfer him into the recovery court because his treatment recommendations would indicate that he would come into recovery court, not mental health court. So we're happy to be able to have resources for him in the recovery court. Any questions? Okay, so then here's our summary. Competency docket addresses incompetence to stand trial individuals not able to understand the nature and object or to assist in one's defense. And have to handle competency before any of the other trial proceedings can occur. The mental health court program is a problem-solving court that offers specialized supervision to competent individuals. And so I believe that's all I have. We can go to questions. Is there any puzzle pieces that I didn't put together? Any questions, any other comments? All right, thank you.
Thank you very much. Here. So it's 9:04, so I understand that some have to head out. But we didn't get to the roundtable update, so for those who can stay, I'll just run through the attendance sheet and those who indicated that they have an update. So Mark. Captain Song.
I have nothing additional to form. Thank you.
Delmonica Hawkins.
Hi, I'm the update. I'm Delmonica Hawkins, the newly assigned regional director for the Department of Services, Central Region. Central Region is Baltimore County, Anne Arundel County, and Howard County. I'm excited to be here. Look forward to working with you all.
Hillary and Candace, you indicated you had an update. Was that beside the presentation? No?
No, I didn't.
Okay, so that was quick. So we can wrap up for February. We'll continue with corrections. We'll do a presentation more focused on inmates. And then we also had the state's attorney's office and the Office of the Public Defender, and then we can dip into the April meeting too, if we need to. So if there's nothing else, do we have a motion to adjourn today's meeting?
Motion.
Do we have a second motion?
Second.
Okay, so today's meeting is adjourned, and we'll see everyone in February. Happy holidays.
Thank you. Chris. Make it a little bit. I'm sorry. What is it? You know, always have. Sir, how you doing?
Yes, ma'am.
Presentation.
Yes.
I'm going to send her.
Yes, I just got it yesterday.
Oh, problem.
Sunday.
Because I know I sent you something, or you sent me. I was CC'd on
Johnson.
C-H.
Candace Johnson. Okay.
I'm not sure, I'm still getting everybody, but I will not, promise, I'm not usually on this whole.
Oh.
Are you?
Are you with the board?
I'm potentially here. I'm with the mental health.
Okay, so that will be at what? Is it?
Yeah, yeah.
So that's your email, VP?
Oh, sorry, it's Baltimore County MC.
Like mine, okay. Baltimore County and okay. And that's the same thing. So is it C
It's
Johnson?
C-H. He's another one. Candace Johnson in this county.
Oh, I got you. We had a bunch of those. Okay. All right, I'll make sure that you're included. Like a week for the next one, and you say, oh my God, you have to send me. Please let me know, like, so I'm trying to learn everybody. So, a lot of people. My name is Kelly.
Kelly.
Yes, La Valley. Just call me Kelly, please. But thank you for being, we had a little glitch in that. Thank you for being. I know, it's better when you can see it up there, right? Everything's nicer visually. I'm sorry about the glitch. It's like.